So if you live in New York City, you probably walk past slip and fall hazards every day without even thinking about them. It can be a wet stair, an icy sidewalk outside an apartment building, maybe even a slick grocery store with no warning signs. And people oftentimes brush off these incidents as minor, but the injuries that can result from a slip and fall can be very serious. And I've seen falls result in broken wrists and elbows, hip fractures, back and neck injuries, and severe head trauma that can really change a person's life in an instant. I'm Jonathan Ratchik, a partner at Kramer, Dunleavy and Ratchik, and we handle personal injury cases here in New York City and throughout New York State. And in this video, I'd like to walk you through what a slip and fall case really is and how these cases work in New York and what one should do after a fall and some of the rules that I think that might surprise people and maybe cause some valid claims. And hopefully by the end of this video, you'll have a much better sense or much better understanding as to whether you might have a case and what steps, if any, you should take following a fall, because timing after one of these incidents is actually more important than many people realize. An important point, which is that just because you fall and get hurt does not mean that someone is automatically responsible or that you have a legal case, okay? The law doesn't say that every injury is entitled to compensation, okay? The key question is whether someone is legally at fault, okay? And in plain English, it usually comes down to this, is whether the property owner, maybe the building manager or the store operator, had failed in their responsibility to keep an area reasonably safe. And where these cases, rise and fall, or where they're won and lost, it comes down to one issue over and over again, and that is the issue of notice, okay? And notice really simply means it's a fancy legal term for knowledge of the hazard or dangerous condition. And sometimes the owner has actual notice about the problem, okay? Maybe an employee saw this bill, maybe someone complained about a broken stair, okay? This is what we would call actual notice. Other times, maybe the store or the owner might say, hey, we didn't know about it, okay? There was a wet condition or an icy sidewalk and we never knew about it. But if the condition was there for a long enough period of time before the incident, such that the responsible party should have discovered it and corrected it or fixed it, the law might still hold them responsible. That's something that we call constructive notice, okay? So if there's a spill in a supermarket that's there for a long period of time, maybe evidenced by footprints going through it, or it's dirty, or maybe there's a loose handrail that's been loose for weeks, okay? The question becomes whether a reasonable owner should have discovered it and corrected the problem. And this idea, what the responsible party knew or should have known, it is really the heart of many, if not most, slip and fall cases. So in New York City, there are a handful of cases or situations that come up over and over again. And one is sidewalks, okay? People trip on cracked pavement, uneven sidewalk flags, broken curbs, patches of ice. Sometimes in restaurants and stores, people in New York City are going out all the time. Spilled liquids, recently mopped floors with perhaps no warning signs out, leaking refrigeration units, water that's tracked in from outside. Those also oftentimes give rise to slip and fall cases. And we see a lot of these falls in apartment buildings and residential properties, worn stairs, maybe poor lighting, loose carpeting. There are even subways and subway platforms and stairs where issues can involve slippery stairs, pooling water, poor maintenance, and leaks. And of course, here in New York City, snow and ice cases are in a category all by themselves. Winter weather, especially in northern climates, they can create real danger, but it also creates legal issues that are not always that intuitive. So here's some of the very specific New York City rules that people need to understand. And the first is that in New York City, sidewalk liability isn't what most people think anymore, okay? It used to be that if you fell on a public sidewalk, the city of New York was responsible, and that's not true anymore. So in many cases, it is the property owner or the owner of the property adjacent to the sidewalk who is responsible for maintaining the sidewalk in a reasonably safe condition. Now, there is an exception for 1, 2, and 3 family homes that are owner occupied and used for residential purposes. But generally speaking, if there's a fall on a New York City sidewalk, it's the adjacent property owner who's responsible. And Now, if a fall happens to occur on governmental property, maybe it's a property owned or controlled by the city or the housing authority, the MTA, there are certainly much shorter deadlines and the rules are very different. Okay. And in cases involving the city of New York, you have to demonstrate that the city had prior written notice of the condition that gave rise to the fall. And certainly in a slip and fall instance where it's a transitory condition, that's usually a very difficult hurdle to overcome. And even in cases like the cases against the subway, against the MTA for conditions in subway stairs, the likelihood that that condition or that the MTA or the New York City Transit Authority had notice of a transitory condition that might cause someone to slip and fall, yeah, not impossible, but probably not likely. And lastly, look, New York, and I think I've discussed this in other videos, it is a comparative fault jurisdiction. So even if you were perhaps careless in the moments leading up to your slip and fall, it doesn't really destroy your claim. Okay, maybe you were distracted, maybe you were talking on your phone, maybe you didn't notice the hazardous condition at the time. Although you might share in the blame, it doesn't necessarily bar you from recovery. Okay, it can certainly reduce the amount that you're entitled to, but don't just assume that you have no case because you may have been temporarily inattentive. All right. So, in the unfortunate event that you are involved in a slip and fall, the steps that you take immediately afterwards are very critical for both your own health and the health of any case you might have down the line. So first and foremost, and this goes without saying, get appropriate medical attention. Okay, your health always comes first, and from a legal, and not just from your own medical well-being, but from a legal standpoint, when you receive medical treatment, it creates a record of what happened. Okay, when it happened, how it happened. It adds an indicia of reliability, which insurance companies are looking for when they're evaluating your case, right? They want to know, did you go seek medical attention right away? How do we know this actually happened, that you slipped and fell here as opposed to falling in your own apartment, right? Assume that you get medical attention right away and you can. And look, if you have the state of mind to do this at the scene, it is always helpful, especially in a slip and fall case, take photographs of the condition which you allege caused your fall. There's that old saying that a picture is worth 1,000 words. It is especially true in slip and fall cases because the conditions that cause slip and falls, they're usually not around for very long. Okay, do it before that spill gets cleaned or gets mopped up again, or perhaps before that worn tread gets replaced. The photograph is going to preserve that evidence that can be used in future litigation. Okay, and don't just take a photograph. Look, everybody walks around with cell phones today, so there's really no excuse not to have to have photographs anymore. It's just a matter of remembering to take them. You can take them certainly close up, which is helpful, but also take them from far away so that there gives or lends some context into the location of where your fall occurred. Okay. If you can, report the incident. Okay. So if you slipped and fell at a store, report it to the manager on duty at the time. If it happened in a building, notify the superintendent or reporter. Maybe if it happened in New York City in the subway, to the station manager. And if you can, try to get a copy of an incident report. They might not give it to you, but at least, again, reporting it validates the claim. It demonstrates that the actual incident did in fact occur. If you can, if there are witnesses to the incident, try to get their contact information. Look, in New York City, I've heard 1,000 times, I had a fall. Lots of people came to help me up. Did you get anyone's name? I didn't. I didn't get any names, didn't get any numbers. And it's hard because people see you fall, they help you up, and then they scatter to the four corners of the wind, right? But if you can get names, cell phone numbers, email addresses, that's always helpful because a witness, again, can be independent evidence that your fall actually occurred. And lastly, be very careful about giving statements to insurance companies or their representatives before speaking with an experienced attorney, okay? What sounds like what might be a harmless conversation can turn into something really damaging evidence if you are not quite, if you're still in pain, if you're not maybe 100% sure about how the incident occurred, or you don't really know what happened. That information is going to be used against you, guaranteed, in litigation down the road. Be very wary about speaking with an insurance adjuster or an insurance company. They're not there to help you. They are there to protect the interests of their insured and to minimize, either to avoid liability altogether or to minimize their exposure for the harm that they caused. Okay. So There are also a few common mistakes that along those same lines that might hurt otherwise valid cases. Okay. And one is waiting too long. And I've already alluded to this already. In slip and fall cases, evidence disappears almost instantaneously. Okay. Surveillance footage gets destroyed, conditions get cleaned up, witnesses get hard to find. Delay is a real enemy of a plaintiff in a slip and fall case because all of that evidence disappears. Okay. And also downplaying an injury at the scene. A lot of people who are involved in these incidents, look, it's embarrassing, they fell down. Maybe they think I'm okay. Maybe they're still in shock and they don't seek medical attention right away. But not doing so can come back to haunt you because, again, getting medical attention, whether it's calling an ambulance, going to an urgent care or a hospital, is important because it proves to the defense counsels, to an insurance company, that your fall actually took place. Okay. It's important that you document that the fall. Okay. So calling the police, calling an ambulance, all of those are steps that will help. It's an indicia of reliability of that what happened to you did in fact really happen. Okay. And don't just assume that because you fell in a store or a building that the insurance company or the building or whomever, they're going to want to do the right thing. Okay. And they're going to want to pay for your medical expenses or your lost earnings. Okay. These cases, they require proof, they require evidence, and people are very reluctant to admit liability. Okay. Admit that they had notice of a dangerous condition that they failed to clean up or that it may have caused you harm. Okay. All of these things have to be developed carefully and to really posture your case in the right way. If you do have a valid, viable slip and fall case, the law allows for recovery of the typical damages that one would expect in a personal injury lawsuit, right? So you can get compensation for your past and future pain and suffering, past and future medical expenses, and other economic loss, such as lost earnings or pharmacy, long-term care, okay? But it's also important to be realistic, right? And the value of a case, the number one question that I'm always asked by every client is always, what's my case worth? And I always give the same unsatisfying answer, which is, it depends, right? It depends on the nature and severity of the injury, how permanent the injuries are, what kind of economic loss there is. But a significant injury with no liability is really not worth anything, okay? Weak proof is very difficult to prove. And conversely, a clear liability, but with weak damages or insignificant injuries also has very limited value. Every case in the end has to be evaluated on its own facts, on its own merits. In every type of personal injury case, including slip and fall cases, personal injury attorneys, we all work on a contingency fee basis, which means that the attorney or the client doesn't have to pay an upfront retainer. Okay. The firm generally fronts the costs associated with prosecuting the case, and there's no fee unless there's a recovery. And if there's a recovery, it tends to be 1/3 of the gross recovery. Okay. But more importantly, not just work, that I think opens up the pool of representation, right? Many persons who are injured in these types of cases would otherwise be unable to afford an attorney. But getting an attorney is also important because the attorney can take steps to preserve the evidence that an individual might not be able to do by themselves, okay? Getting reports and records, obtaining photographs, preserving surveillance footage, getting statements from witnesses, and making sure to satisfy the requirements or the evidentiary requirements that are needed to have a viable personal injury lawsuit, okay? In all these cases, details matter, even small, what you might think are insignificant details matter a lot. The attorney can find out who owns the property, who is operating or managing it, who is legally responsible for the condition that may have caused your injury. So if you were injured in a slip and fall incident here in New York City or throughout New York State, my advice is always simple, okay? Don't guess, don't wait, and don't assume that you don't have a case, okay? Just because the situation might seem a little complicated. These cases turn on facts that are not always obvious in the first day or two. So if you want to understand what your options are and get the facts, speak to an experienced personal injury lawyer, okay? A consultation, they're always free, okay? And you can figure out, come to understand what deadlines apply, what steps you might need to take before important evidence disappears and to preserve your rights. So again, Jonathan Ratchik, Kramer, Dunleavy Ratchik, thank you again for watching. And if you have any questions or about a fall injury, I'm happy to help, happy to talk to you.